Hello, everyone. So I was going to come and start recording part 6 of the. Oh, got to orientate myself now. It's the Rule 56.1 statement, Lively's opposition to it. So we've had a few letters overnight hit the docket. So I wanted to go through them. So we're interrupting this broadcast for a service announcement. We're going to look at Popcorn Planet. They have filed a notice to appeal, which I anticipated and I'm really pleased to see. Blake Lively filed her reply to Wayfarer's opposition to her request to supplement her Rule 11. I've got some thoughts on that as well now I've read it. What else is there? Oh yeah, we have an order. Okay, so we have this order from Judge Sarah Cave, which has been filed today. No, sorry, on the 10th. On the 10th. I keep reading the date wrong. I'm British. Okay, so it was on the 10th of December. This is from Sarah Cave, who is a magistrate judge. You'll remember that Judge Lyman referred the parties to enter settlement talks, which is normal. I have to state that because I've seen a lot of people saying, "Oh, Judge Lyman's forcing them to have settlement talks." On a technically, yes, that's what you could call it. That, however, every civil case has to do this before trial. You cannot just go, skipping off to a trial. So this has to be attempted. It could break down. They could just haven't attempted it, decide it's not for us, or no, there's no negotiation here, there's no common ground, and then they just get to proceed to trial. That's it. So he's not forcing them to enter settlement so that they definitely 100% avoid trial because he doesn't want them to have a trial. It's nothing like that at all. This is perfectly normal. Happens in the UK as well. I did say this when Lyman's order came out. If you even want to get divorced, you have to attempt mediation, except for certain quite extreme situations like, domestic violence, where, they have exemptions in place. Because, clearly you're not going to be able to mediate for those kind of reasons and find, try and attempt to work through and save your marriage, nor would you be expected to. However, all civil cases, that's family law as well. You got to try and attempt mediation, etc. You have to go through this process. Debt, in the case of debts and contracts, you've got to try and settle. Employment law, you've got to try and settle. So this is perfectly normal, and it is not. I just want to kind of really try to kill that presumption that people have that this is Lyman trying to prevent Wayfarer from having their day in court or save Lively from a trial. He's not. Okay, so he will be doing this to every other civil case he's got, in his caseload, as will any other judge. Okay, so we have this order from the magistrate judge. And what it basically says is, this action has been referred for the undersigned for settlement. Accordingly, a video conference to discuss scheduling a settlement conference is scheduled for Monday, December 15th. So on Monday, they're going to have a video conference to discuss scheduling a settlement conference. This is not the actual settlement conference. It's going to be at 4 p.m. Eastern on Court's WebEx platform. Because the discussion will relate to settlement, attendance at the conference will be limited to counsel for the parties. Okay. The parties shall be prepared to discuss their availability and that of their clients for a settlement conference, as well as their preferred format for the settlement conference in person, by telephone, or by video conference. The parties must promptly execute and return the annexed attendance acknowledgement form with the names and email addresses of the individuals who will be attending the conference, following which the court will provide a link for conference. And that is the form they have to complete. This will not be a public thing that, we can dial into like Judge Lyman often has. The reason for that is settlement negotiations are confidential. They're quite commonly wrapped up in a non-disclosure agreement. There is no right of public access to know the contents of this agreement. So we will not hear about it. The only way really we will know whether it is failed or not is, if the case keeps proceeding, basically. Something may be filed on the docket, but there may even be an order to say, following this is what is going to happen. Or, following this conference, a settlement has been agreed and, this case is now withdrawn or dismissed with or without prejudice. So unless we see something like that, we're not going to know any more detail than that. So that's the first document. And I appreciate there's there's some other letters as well, but I just want to do these 3 documents in particular and then get back to, I think Wayfarer requested for an extension of time of expert discovery, and that has been granted. But I won't go into the whys and whys of that. Oh, different docket, innit? There's so many dockets. I'm chasing my tail, finding out which one I need to head to. So, Popcorn Planet. Okay. This is a very brief letter, one I'm really happy to see and I was hoping to see. Movement Popcorn Planet hereby gives notice of its appeal to the United States Court of Appeals for the 11th Circuit from this court's order entered on December 2nd, 2025, as well as from all earlier rulings, opinions, and orders adverse to it in this case. So, Andy was ordered by the Florida judge to his motion to quash was denied, and he was ordered to turn over all the documents requested by Lively by the 17th of this month. I think it was the 17th. He is now appealed. As a result of that appeal, I think I'm correct in saying that, he now does not need to hand over anything because the appeal is pending. The chances of the appeal being heard before the trial in March, I would think, are very, very slim. That's not a guarantee. That's definitely not a guarantee, and it's not, something that I am, any expert in. But look how long these things are taken. Lively's trial date has just been delayed by 2 months as well. But even still, like, appeals courts are normally, there's even bigger backlogs. So I would be surprised if the appeal was heard in time for the May trial. So unless the May trial is further delayed, and Lively could, in theory, say that she is waiting for this. I don't know. She may not. I don't know if it would make a difference either. In the UK, these things would matter and would delay a trial, pending outcome of appeal. That is probably something that little girl attorney, or not actually Golden, could probably weigh in more on. But yeah, so that is underway, and a notice of appeal has been filed, so we will just wait for Andy's appeal documents. Finally, oh, I closed down the wrong screen. It's been one thing after the other, in the last day or two with my computer. Last night I lost internet while during the recording of part 5. I think I lost about 5 or 7 minutes. I had to go and like clip them out. I didn't realize until I had already done nearly an hour's worth of filming. I was like, I'm not going back to film all of that again. So just I'm not good at editing. That's why I try not to do editing. I try to do just a one take video. So if I get tongue tied or something, you know, I don't go looking for it to try and clip it out. It's a human error, you know. Say something or get the right word wrong, or you know, fall over my words. It happens. Okay. That's me waffling while I find this letter. Yeah, then I wanted to wrap up with this letter because it is a really, really, really angry letter from Michael Gottlieb. It is concerning, so basically, we had fully briefed motion for Rule 11 sanctions back in about, I think it was May, from both Blake Lively and Ryan Reynolds. Blake Lively then did depositions. She then filed a letter for supplemental response to add to the motion on behalf of both her and Reynolds for the Rule 11 sanctions. Wayfarer asked that the judge either deny it or allow them to file the decent response back, which the judge allowed them to file their response. So they did. It was a good response. However, Lively then got the reply to fully brief. And as I've gone looking through this, the one thing I think from Wayfarer is I think when their response was decent, it was. I think Lively is reaching here. I think Wayfarer also thinks she is reaching here. I think the most important thing for them to get on the docket was a bit of PR in their opposition, and I will tell you why when I get there. Okay, so Blake Lively and Ryan Reynolds, the Lively-Reynolds parties, respectfully submit this reply in further support of their letter motion to lodge supplemental material in support of their pending motions for sanctions pursuant to Federal Rule of Civil Procedure 11. None of the Rule 11 plaintiffs' arguments in their responsive letters, bear in mind the plaintiffs in this scenario are Wayfarer. Normally plaintiff is Blake Lively. These sanctions are filed in response to Wayfarer's lawsuit against Lively. This is not Lively v Wayfarer, this is Wayfarer v Lively. So just to remind everyone of that. So when I say plaintiffs, I'm actually talking about Wayfarer. Lively and Reynolds are the defendants. Okay. None of the Rule 11 plaintiffs' arguments in their responsive letters provide any valid basis for the court to ignore the Lively-Reynolds parties' supplemental material in support of their Rule 11 motions. To the contrary, I like it when she uses these sentences because it's like, "Ooh, what we got?" And then it usually turns out to be a big fat nothing. To the contrary, the primary purpose of the submissions appear to have been to serve as a vehicle for filing Mr. Reynolds's text messages on the public docket, none of which have anything to do with the supplemental material Lively Reynolds offered exclusively with respect to Sarowitz and Abel. And I do agree with that. That's the PR. I do agree with that. The responsive letters offer no conceivable basis for either Sarowitz or Abel in their individual capacities to have sued Miss Lively or Mr. Reynolds for anything, and rather merely offer excuses for Sarowitz and Abel's undisputed testimony that the Rule 11 plaintiffs admit corroborates the Lively Reynolds party's Rule 11 arguments against them. So that's true. There is nothing that Sarowitz or Abel can use any, like their Ryan Reynolds text messages have no bearing on Steve Sarowitz or Jen Abel filing the lawsuit against Blake Lively and Ryan Reynolds. They don't, because Ryan Reynolds is not alleged to have said anything about them. His alleged defamatory statements, which, in my opinion, Lively does not actually deny in this letter, are targeted towards Justin Baldoni, maybe Wayfarer, but Justin Baldoni. I don't know if it's mention of Jamie Heath as well, but definitely not Sauritz or Abel. Okay. I just also want to point out as well, whilst Lively is jumping up and down like a toddler having a tantrum over, oh, well, you used this as a vehicle to file his text messages. Those text messages are discovery that Wayfarer have obtained. They can file them if they want. So I don't know why they're whinging about it. All the crap that Lively has filed, which is completely irrelevant and sealed because she doesn't want anyone to see it. You know, what can we say? But I do think that the Wayfarer took advantage of this letter somewhat to get those text messages on the docket, because we've seen nothing from Lively or Reynolds so far. And Lively kicked up such a stink when Wayfarer included Justin's text message thread with their personal trainer, Don Zaldino. You know, she was like, oh, how dare you didn't ask his consent, blah, 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 blah. Well, I don't remember her asking for Jen Abel's consent. In fact, I remember her going out of her way to avoid getting Jen Abel's consent to share her messages. But, you know, rules for thee and not for me. Okay. I will get off my soapbox now. First, the Rule 11 plaintiffs cannot dispute that their counsel and at least Sauritz and Abel filed and maintained claims against the Lively Reynolds parties that were objectively baseless by attempting to denigrate the proposed supplemental evidence as merely corroborating evidence already submitted in support of their original Rule 11 motions. Rule 11, plaintiffs confirm what the Lively Reynolds parties have already shown, that Sauritz, Abel and their counsel asserted claims against the Lively Reynolds parties with no arguable basis in law or fact. The Lively Reynolds parties are happy to agree that the supplemental evidence is merely corroborative, in the sense that it's not necessary but rather helpful for the court to consider in order to grant all the relief requested in the Rule 11 motions. But the Rule 11 plaintiffs' opposition to the court's consideration of that evidence is meritless nonetheless. For example, the Rule 11 plaintiffs argue that Abel and Sauritz's testimony should be disregarded because corroborating testimony is supposedly not proper to supplement previously submitted evidence. But that misstates the import of Joint Stock Co., which involved and rejected a request to reopen and expand the scope of an already decided Rule 11 motion beyond the scope of the Rule 11 notice that had been served on the non-moving party. Contrary to the Rule 11 plaintiff's description, that case did not hold that it is improper to supplement a pending Rule 11 motion with evidence that corroborates Rule 11 violations within the scope of the served notice. And as the Rule 11 plaintiffs concede, nothing in the rule or the advisory committee notes permits or prescribes supplemental evidence or submissions. Second, the Rule 11 plaintiffs' truncated quotation from the 1983 advisory committee notes conceals the reason for that general practice that discovery in aid of Rule 11 motions is not the norm. In the excised part of the relevant paragraph, the committee explained that discovery is normally inappropriate because, to assure that the efficiencies achieved through more effective operation of the pleading regimen will not be offset by the cost of satellite litigation over the imposition of sanctions, the court must, to the extent possible, limit the scope of sanction proceedings to the record. Here, where the evidence at issue was developed through discovery on Miss Lively's affirmative claims, In the consolidated related case, that concern is non-existent. Realizing this, the Rule 11 plaintiffs argue that whether Abel or Sarowitz lacked proper grounds to assert the dismissed claims is irrelevant to Miss Lively's pending affirmative claims, and the only purpose of this line of deposition questioning was to obtain discovery to support Lively and Reynolds' Rule 11 motions. And I thought that was actually a really good argument, because why would you still be asking about that months after the claims were dismissed? However, we should also remember that Wayfarer have also been quite vocal that they intend to appeal. So, although the claims are dismissed, and Wayfarer have kind of portrayed it as, well, the claims are dismissed anyway, what are you worried about? It is important to remember they have said they will appeal. And I think Lively does get to that in here. But that too is incorrect. Ms. Lively alleges that Abel and Sarowitz participated in and furthered a conspiracy to retaliate against her for raising concerns about Baldoni and Heath's conduct by, among other things, joining a retaliatory lawsuit against her. As this court has made clear, the scope of permissible discovery is judged against the operative complaint as pleaded, not against the defendant's cramped view of what they think Miss Lively should be allowed to learn in order to prove her claims. I think if Lively hadn't sued Jen Abel and Steve Sarowitz and named them in her CRD and in her lawsuit, which was filed first, they would not have joined this lawsuit. So I don't think they joined it just to retaliate against her. They joined it because she is suing them. Okay, third. The Rule 11 plaintiffs also make the surprising claim, irrelevant to the question whether the Lively Reynolds parties should be permitted to supplement the record, that they satisfied Rule 11 by declining to amend their complaint after the court dismissed it. And here's where I think she's going to bring up the appeal. Although they admit that the claims were not dismissed within Rule 11's 21-day safe harbor period, nor were they ever actually withdrawn by the Rule 11 plaintiffs. The Rule 11 plaintiffs contend that they had every right to wait to see the court's ruling on the motions to dismiss before evaluating their compliance with Rule 11. Okay. That is flatly wrong. The time for compliance with Rule 11 is when the challenge pleading was filed, and the time to withdraw a challenge pleading is within the safe harbor period. The law is clear on this point. A party cannot, without good faith basis, assert a claim, fail to undertake a reasonable inquiry into whether an evidentiary basis exists to support the allegations, and, after discovery confirms the absence of such a basis, avoid Rule 11 sanctions by withdrawing the claim. As such, the plaintiff's wait-and-see argument offers no excuse for their failure to comply with Rule 11. Had the Rule 11 plaintiffs wanted extra time, they could have sought an extension of the 21-day period under Rule 11C2. Otherwise, any argument that the 21-day safe harbor provision is too short and should be lengthened is best addressed to the Advisory Committee on Civil Rules. The existing period appears to strike a careful balance between the rights of those accused of sanctionable conduct and those who may be needlessly defending a baseless claim. Citing no authority, the Rule 11 plaintiffs go so far as to suggest that their decision not to amend the complaint is equivalent to a timely withdrawal under Rule 11C2. This argument is absurd on its face. They undisputedly did not timely withdraw or appropriately correct the challenged paper. Nor have they conclusively abandoned their claim because the time to appeal has not expired. And the Rule 11 plaintiffs have not waived their right to appeal. To the contrary, their counsel has publicly stated that his clients chose not to amend their complaint to preserve appeal rights, elaborating that if you're familiar with standards of appeal, sometimes you don't do that because you have a better chance of winning on appeal based on a dismissal of the first complaint rather than a subsequent complaint that you might amend. There's a footnote. Yeah, so she's talking about when Friedman said that. In short, it offends the very purpose of Rule 11 for the subsequent complaint, for the Rule 11 plaintiffs to argue that Abel and Sarowitz's voluntary decision to withdraw the claims, something they did not do, had precisely the same result sought by Lively and Reynolds' Rule 11 notice letters. And the arguments she's making are not actually unfair. I don't think the Rule 11 sanctions is the motion, I don't think is particularly strong anyway, because the judge didn't say that the complaint was meritless. He said it was not well pleaded, and in most of the defendants, all but Lively, there was no evidence of actual malice. And the thing is, right, is while she's saying, well, you're throwing in stuff about Ryan Reynolds potentially being defamatory, you got text messages you want to throw in, etc. They don't apply to Sarowitz and Abel. And then whilst that's true, the complaint was a group pleading. So she might be able to say, well, okay, sanctions are warranted for Sarowitz and Abel. But I think that's pretty much going to be it. Possibly Nathan as well, but she doesn't bring up Melissa Nathan here. And she can't with the supplemental because it's only, she's relying on deposition testimony, what Abel and Sarowitz said in the deposition. And obviously, if Melissa Nathan didn't make the same statement, she can't use it to supplement anything. Okay. Fourth, the Rule 11 plaintiffs protest that the cited testimony was given on the heels of attorney-client privilege objections and instructions not to respond with information learned exclusively through communications with counsel, and that Abel and Sarowitz attempted to respond based on their personal knowledge, struggling to respond without divulging attorney-client communications. This misses a point, as the Lively Reynolds parties previously made clear. Had Sarowitz or Abel ever actually experienced extortionate threats from Miss Lively or Mr. Reynolds, they would not have had to learn about them from their lawyers. I do remember Steve Sarowitz saying, well, I'm not a lawyer, when asked, why did you file this complaint? He did actually say, well, I'm not a lawyer. Okay. Finally, the Rule 11 plaintiffs assert, once again, that Rule 11 sanctions are not appropriate where there is good faith belief that discovery will yield evidence to support a claim. But they have failed to demonstrate any such good faith belief as to the challenged claims. Once again, they cite statements uncovered in discovery that they assert constitute evidence of defamation by Reynolds, albeit evidence they concede was not in their possession at the time of filing. First of all, the emergence of new evidence does not retroactively demonstrate good faith at the time of filing. If there was no objectively reasonable inquiry and no good faith basis for the allegation at the time of filing, then a party is not entitled to wait and see whether he or she might get lucky in discovery and find some support to retroactively bless the pre-complaint inquiry. Seriously? Blake, this is Blake Lively, right, who has had no evidence of a smear campaign and was hoping to find it in discovery the whole time. She's also filed an alternative sanctions motion for spoliation, saying, well, you deleted all my evidence. How can you prejudice me? How can I prove my claims without them? But here she's like, well, Wayfarer can't rely on evidence they found during discovery. They can't just, say, well, we were just hoping to get lucky. When that is exactly what she's done, and she has filed almost like the opposite end of the scale of motions that, she needed discovery that they have deleted deliberately, because she needed it to prove her claims in a lawsuit that she has already filed without that evidence. This woman is nuts. Right. Okay. But here, the Rule 11 plaintiffs did not even get lucky because the evidence they cite is irrelevant to the challenged claims. The cited evidence is irrelevant to the supplemental evidence submitted by Lively Reynolds related to Sarah's and Abel, which claims were not nor could have been based on alleged defamatory comments regarding Baldoni or Heath. Accordingly, the cited evidence is utterly irrelevant to the supplemental material. And there we go. Some decent points. I mean, I don't think the overall, like I said, I don't think the overall motion is particularly strong. So I think Wayfair are like, we don't care. They made some very good points in their opposition, I think. In the original motions back in May, they filed oppositions, which were again very good. I think they're kind of like now at a point of, like me, kind of just a big long sign. Oh, geez, here we go again. She's filing crap, trying to make she is slightly trying to twist things, which are ridiculous. However, I do think that Wayfarer did actually. I think the text messages from Reynolds, if they do prove defamation, then yeah, I think that's absolutely worth pointing out. Do I think they hopped on to take advantage of that a little bit to get something from Reynolds on the docket? Yes, I do. They're currently sealed. Obviously, when they get unsealed, I will be breaking my ankle to get here to have a look to see what it says. All right. So now I'm going to go back to the Rule 56.1 oppositions from Lively. I think by the time you listening to this, the first 5 parts will be out. I think we're about halfway through. We've still got a fair amount of time to get through this. But however, where I left off, we were about to start Van Zan, so it's getting interesting. The only other thing I want to say is because when I did one of the videos, I filmed it last night and then scheduled it for today because I mentioned I was having to take my daughter to a pre-op assessment for surgery she's due to have next month. I've had lovely messages from many people wishing her well and messages of support. I want to say thank you to everyone. I really appreciate people taking a moment to just write something really kind and considerate like that. I do reply to everyone where I can, even if it's just an emoji or something, or I'm just reacting with a heart. I do attempt to reply to absolutely everyone, but I do want to say, because there's a lot of videos coming out, there's a lot of comments, so I may miss comments. That is not deliberate at all, and I will catch up. But I want to say, like a blanket thank you very much to everyone who has said really kind, supportive things, left comments of any nature or questions. And people who bought the some of the t-shirts, the merchandise, thank you. People who have been kind enough to leave super chats or super thanks, thank you very much as well. My memberships, people who are members of the channel, thank you. Please do like and subscribe, and if you can, hype. But I will be back very soon with the next segment of the 56.1. I'm doing it in roughly 40 to 50 minute videos, trying to break it down into smaller chunks for people. There's been overwhelmingly positive response to that, so I'm going to keep doing that for the bigger filings going forward, because that seems to work for both me and for you guys. And yeah, we will be going into the Van Zan of it, so please do join us. All right, have a good day.